There's a big difference between substituting out from a case or being relieved as a counsel. One, substitution is just one form where a client signs it, an attorney signs it. A new attorney can also sign it as an entering attorney. It means it's a voluntary termination of attorney-client relationship. The second version is when a lawyer has to file a withdrawal motion to be withdrawn as an attorney on the record. And that creates a record, which means anyone who can access the court's docket can see that the lawyer has filed it. The first thought that the next lawyer will think is either the client didn't pay, or there is a problem with a client, or a big problem with a case. And it creates a huge red flag. If there is a problem between attorney and client, and attorney says, please sign substitution of attorney, sign the substitution of attorney right away, because you will eliminate 90% of the chances of getting a new attorney you like by not signing. So, if the lawyer does have to file a motion to withdraw as an attorney on the record, ethically, they're not allowed to disclose confidential information. They cannot say, oh, this case is complicated and the client is disaster and doesn't pay my bills and complains all the time and makes my life miserable. No, the lawyer is not allowed to say that. The lawyer is allowed to say, and there are 2 cases of appeal where the lawyer is allowed to say 2 things. If the client doesn't pay, it's called involuntary servitude. Slavery has been abolished a long time ago. A lawyer doesn't need to work if the lawyer doesn't get paid. Second reason, breaking down in the relationship. You know, everyone knows what it means. Between the lines, it's exactly what I just said before. So then there is an opening for the judge. If a lawyer attempts to get out a month before trial, that's a problem because it's too close, and then the judge is allowed to take the lawyer in chambers and ask questions exactly why are you substituting out. And this doesn't open up a relief from confidentiality. The lawyer can explain things that are non-confidential. For example, well, I'm not getting paid. It's a borderline not confidential because case of appeal says involuntary servitude, which means or the client violated retainer agreement, keeping it vague without disclosing confidential details. And even then, it's a very gray area. So in other words, I haven't seen a case where a judge would not relieve a lawyer from the record. The judge usually does that because nobody can force someone to work against their will for free. And if you're a client who has been asked to sign a substitution, please sign because, as I said, it will create a really, really bad record for you. So what else? If you feel that the lawyer sends you the substitution too close to a hearing and you're afraid that you won't find a new lawyer or that you don't want to go to that hearing alone, then ask your lawyer to help you with the continuance of the future hearings. And the lawyer will gladly do that before filing a withdrawal because every lawyer knows that if they have to file a withdrawal, that means it's really bad in the relationship. So, and you won't get lawyers' cooperation as much once they file a withdrawal for other things. So, however, once the termination is complete, whether it's substitution or withdrawal order, the lawyer has to provide the entire file and all the information that's coming up, hearing, deadlines. If there is anything else regarding deadlines or hearings that needs to be done, the lawyer needs to disclose that, especially if the client is going to be not represented by another attorney. I hope that was helpful. If you like the video, like, subscribe. If you have any ideas for my future videos, please share down in the comment section below, and I will see you in my next consultation. Bye!